Hello, everyone. Welcome to our lesson on international law. And this lesson will be on international organizations. International organizations are legal subjects of international law. They are legal persons, legal public persons, like states. They have legal personality, legal capacity to act in international law. They can act in international law. It means that they can accomplish legal actions in international legal order. They can adopt measures, legal acts, they can sign and they can adopt treaties, conventions, they can adopt regulations, resolutions, so they can have normative actions in international legal order. They can own rights and they can have duties, legal rights and legal obligations. For example, an international organization can have bank accounts, can hire agents, persons, workers. For example, United Nations workers are hired by United Nations. They have a contract, a legal contract between these persons, this person working in a United Nations and the United Nations as a legal person. So they can also engage their legal liability, their legal responsibility in international legal order. So international organizations are, as states, legal subjects of international legal order, but the main difference is that the international organizations have no sovereignty. This is the main difference between international organizations and states that we studied last week. I think in midterm examination, there can be a question about state, the concept of state, and also the distinction between state as a legal person and international organization as a legal person. So the main difference between a state and the international organization is that the international organization has no sovereignty. International organizations are functioning on the basis of the principle of conferral. Principle of conferral, it means the principle according to which an international organization cannot go beyond its competencies, its attributions. There is no unique definition of what an international organization is. There is no unique legal definition, but we can take into account a definition given by the Article 2 of the draft articles on the responsibility of international organizations, draft articles formulated in 2011 by the United Nations International Law Commission. According to this definition, an international organization is an organization established by a treaty or other instruments governed by international law, possessing its own international legal personality. I repeat, an international organization is an organization established by a treaty or other instrument governed by international law, possessing its own international legal personality. As we can see, the legal personality, which means the legal capacity, the legal ability to conclude legal acts, to have legal rights and legal duties, is the main element, the main ingredient of the definition, of the legal definition of international organization. So I would like to resume the difference between international organization and states. The first difference is that the state is established by constitutional process. A state is established by constitutional process. It means that there are political and historical constitutional movements explaining the creation of the state. For example, a revolution, for example, a war of independence, as it was for Turkey, for example. But unlike a state, the international organization has no constitutional establishment. There is no revolution or another thing establishing, creating an international organization. The creation of the international organization is a contractual creation. It's a conventional creation. There must be a treaty, there must be an agreement between sovereign states. There must be a convention creating the international organization. The second difference that I have already told, and I think this is the main difference, is the sovereignty. The state is a sovereign legal person. State has sovereignty, which means the free will. The sovereignty is the free will, is the supreme power of decision. So sovereignty lets to the state the ability to create ex nihilo, it means from nothing, the legal order. State can create as a whole the legal order. The law is a creation of the state by its sovereignty. And then state can also create international organizations. What I mean is that the international legal order is created by states, by sovereign states, by their free will, by their conventions, written rules, or by their behaviors. International customs, for example, are behaviors of states. And states, sovereign states, can also create international organizations. International organizations have no sovereignty, they have only competencies, they have only attributions. States, as international legal person, they are governed by the principle of sovereignty, but international organizations, although they are also legal persons of international legal order. They are governed by the principle of conferral. It means the principle of conferral means the principle according to which international organization can only exercise attributions, competencies determined by its founding treaties, by its founding conventions signed by member states. So this is the main difference between states, and these are main differences between state and international organization, and which allows us to give a general, global, legal definition of the concept of international organization. I would, after those preliminary explanation, after this definition, I would like you to present several points of the creation of international organizations, first of all, and then some words. I will tell you some words about the classification of international organizations, and I will finish this lesson by telling you some information about the general rules of functioning of international organizations. First point is about the creation of international organizations. International organizations are not original subjects, genuine subjects of international law, as we saw. Only states has this quality. International organizations, they are created by international law itself, by contracting states. So we can call those international organizations as derived subjects, derived legal subjects, secondary legal subjects of international law. States are not created by international authorities. They are creators of international law. But it is true that there is a contrary movement in the sense of the limitation of sovereignty of states. Thanks to their independent institutions, by their authority, by their normative authority, international organizations can limit the national sovereignty. For example, United Nations, the Security Council of United Nations can adopt resolutions, mandatory resolutions, in order to limit national sovereignties. The example that I can give you is the example of the resolution 541, the resolution 541 of the United Nations Security Council. In this resolution, the Security Council prohibits to all states the legal recognition of Northern Republic of Cyprus. This is a mandatory resolution, and so why only Turkey is recognizing the Northern Cyprus Republic. Another example is given in European Union law. In European Union law, which is an international organization also, even though it's not a classical international organization, but integrative international organization, the European Union can also adopt acts limiting the national sovereignties. For example, Article 288 of the Treaty on the Functioning of the European Union announced that EU regulations have general application, are binding in their entirely and directly applicable in all member states. So when European Union adopts a regulation of harmonization, the European rule, will limit the national sovereignty. Also, as you know, the European Union, and we will see, is regulated by some principles very important, as the primacy of the European Union against national orders, national laws, and the principle of direct effect of European Union. So all those rules are limiting national sovereignties. So the international organizations can be created by founding treaties, which we will call, for example, as convention, as statute, as treaty, founding treaty, and they will be the primary law of the international organization. The establishing treaty, the founding convention of the international organization, will be the supreme norm of the international organization. And we will call this supreme level hierarchy of international organization as primary law. This primary law will be on the top of the legal hierarchy of the international organization. It will have primacy and supremacy on all other legal acts of the international organization. And then under the primary law, under those treaties, under those conventions establishing the international organization, we will have secondary law, which will be constituted by legal acts of the institutions of this international organization. There will be a hierarchy between secondary law of the international organization and the primary law of the international organization. So there will be a legal system. All international organizations will constitute a legal order, a hierarchical legal order. At the bottom, we will have the primary law, and then under this primary law, we will have secondary law by legal constituted by legal acts of this international organization. And as primary law norms are superior to secondary law norms, secondary law norms must be conformed to primary law. So there will be a legal organization, a legal hierarchy, a legal order inside of each international organization. We will have, for example, in the European Union, we will have European treaties as primary law, and under those European treaties as primary law, we will have secondary law, which will be constituted by Article 288 instruments, which are regulations, directives, and decisions. Each international organization is a legal order, and it is created by member states or by other international organizations. For example, the European Union can be a member of another international organization. organization. It is the case, for example, in the World Trade Organization, WTO. In World Trade Organization, the European Union also is a member of this international organization. But mostly, international organizations are created by states, and the quality of member states is a specific legal statute which allow to the member state some rights and some duties. Member states in international organizations have, for example, right to vote and right to participate to decisions of institutions of the international organization. And I would like you to know very well the distinction of voting modalities in a general aspect. The difference between unanimity, vote by unanimity, the vote by consensus, and the vote by majority. I think the knowledge of differences between those voting modalities are important for you to understand. The vote by unanimity is generally adopted in classical international organizations, which are intergovernmental organizations, and the unanimity preserves the sovereignty of all member states. Voting by unanimity makes difficult the decision, the institution of a decision, the realization of a decision, but it protects all member states, their sovereignty, their full sovereignty, because they allow to all member states a right of veto. Unanimity is a vote by all member states, so when a single member state is not okay with the decision, is not admitting the decision won't be adopted. The vote by consensus is also very protective of the sovereignty, national sovereignty in international organizations. We can find this voting system, for example, in NATO, North Atlantic Treaty Organization. Consensus, let me explain what it is. The consensus is not a formal voting system. Member states won't formally vote a decision, but they will discuss a decision, they will negotiate a decision until finding a solution, comprehensive solution, admissible by all member states. So the consensus is also very protective of sovereignty, because all will of every member state will be mixed in the final decision. The last voting system is the majority system. This system is less protective of the national sovereignty. It's more limitative of national sovereignty, because the decision will be adopted even though several member states, minority of member states, are opposed to this decision. So also majority can be simple majority or qualified majority. So the decision making can be more or less easy. It depends on subjects. We can find this modality of voting, especially in integrative international organizations. For example, in European Union, European Union limit the sovereignty of national states. It limits member states' sovereignty, and it makes possible more easily the decision making by adopting the majority system. But majority system in the European Union is very complex and limited, and we have some alternatives. We have some limitation to this system. For example, we have a blocking minority technique, which allows to several member states which are not happy about the decision to block the decision making. Member states have also some duties in international organizations. They have the duty to respect their engagement in international organization. For example, they have the obligation to make sincere cooperation. We can give the example of Article 4 of the Treaty on the European Union. The sincere cooperation means that member states will do anything possible to make to realize objectives of the international organization, and it will do nothing to hindering to make obstacle to the realization of those objectives. Member states always participate actively to international organization decision-making process by their bodies, international institutions, the organs of international institutions. There are three types of bodies, three types of organs in every international organization. There are decisional bodies, decision-making institutions. There are executive institutions, administrative and executive institutions, and there are judicial institutions nearly in every international organization. For example, in United Nations, in the Organization of United Nations, we have the decision body, the Security Council, which is the decision body. The Security Council of the United Nations can adopt the mandatory resolutions, as you already saw. It's composed by 5 permanent members and 10 non-permanent members, and all 5 permanent members have a right of veto, which blocks the decision-making process of the Security Council, as you know, and which is the weakness, which is the most important weakness of the international legal order today. United Nations has also executive body. It has the Secretary General, which is also the administrative authority of the United Nations, and executive as an executive body, the Secretary General prepares the unions meetings and adopts publish the decisions of the organization of the decisional institutions of the United Nations. As judicial organs, we have in United Nations we have the International Court of Justice, which is a judicial organization, and which is composed by judges from member states, judges appointed by member states, but which are independent from national governments, and which give also binding decisions, judicial decisions. But as you know, maybe the judicial competency of the International Court of Justice is very limited. It requires the acceptance of the member state, which is in litigation before the ICJ. So there is no possibility to be attacked before the ICJ if the state doesn't recognize the competency of the ICJ. This legal statute of member states can be lost in case of withdrawal. The withdrawal means the retirement of the state from the organization can be a voluntary decision. A member state can quit the international organization. We saw the example of United Kingdom, which quitted the European Union, which leave the European Union. In a legal term, it's named withdrawal from the international organization. And according to Article 50 of Treaty of European Union, it's possible to quit, to leave the European Union. Maybe I can tell you the Article 56 of Vienna Convention, which is interesting about this point. There is no absolute right for withdrawal from international organizations according to Vienna Convention. There are two conditions for leaving an international organization. And the first condition is that parties, the withdrawal must be possible according to the intention of parties. For example, the fact that in the Treaty on European Union we have the Article 50, it shows that the withdrawal is possible. And the second possibility is that the withdrawal is also possible if the nature of the international organization allow this withdrawal. It is, for example, the case for UNESCO. I don't know if you know, but Israel and the United States are withdrawn from UNESCO after the accession of Palestine as a member state in UNESCO. The withdrawal, the exclusion, can be also involuntary as a sanction of the membership, as a sanction of non-respect, non-compliance to international obligations of the member state. We have, for example, Article 5 and Article 19 of United Nations Charter, which enumerates some sanctions against member states which are not complying with their international obligations before the international organization. And we have also the Article 7 of the Treaty on European Union, which which establish a sanction procedure against member states which are not respecting, for example, the principal values of the European Union as the rule of state, or human rights, or democracy. The procedure of Article 7 was tried against Polish government, against Hungarian governments, but they didn't finish, they didn't concluded. There were some alternative solutions. There are some alternative solutions to make pressure on those governments. For example, Hungary or Poland or Romania were condemned by the Court of Justice because of the violation of the rule of state in those countries. And also there is a new regulation of the European Union, which limits the conditions to get European aids, European foundation, European fundings, subvention for those countries. Another example of withdrawal is, of course, the Russian Federation, which left the Council of Europe in March 22 because of the Ukrainian war. There was a sanction procedure begun by the Council of Europe, started by the Council of Europe. And before the end of the procedure, before the end of the sanction procedure by the Council of Europe, according to Article 8 of the Statute of Council of Europe, the Russian Federation quitted the Council of Europe. Yes, I would like to make a little pause and then we will restart. Let's make a little stop of 15 minutes.